Greetings to you all and welcome to Grade 8 Tutor. My name is Afari Ernest and I'm going to be the facilitator for today's lesson. We are going to look at Unit 5 of Business Law and the topic is Discharge of Contract and Remedies of Contracts. Okay, so when we talk about discharge of contracts, what do we mean? So that is what we are going to look at. So basically, when we say discharge of a contract, it means ending the contract and releasing all parties from their responsibility. So once a contract is discharged, it means no one has anything to do under the contract. Okay, so we had a contract that you are supposed to do this, I'm supposed to do that. Once we are done with it, no one is under the contract again. That is what we mean by discharge of what contracts. Okay, so the lawful means by which one of the parties would be free from obligations are, so we have one by performance, a situation whereby you can be discharged of a contract is one by what performance, right? Then another one is what by agreement between what the parties or a mutual decision. Then the third one we can also talk about by frustration, and the last one that is by breach of a contract. So that one is unlawful means of what termination. Okay, so let's look at them one after the other. Okay, so the first one is by performance. By performance. So when we say by performance, performance must be complete, precise, and exact of entire contract terms. So the normal way in which a contract is discharged is that both parties perform their obligations under it. So once we have a contract and both parties perform their obligations or their duties under the contract, it means we are done with what the contract. There's nothing else to live upon. Okay, so let's look at some things under it or some of the obligations that we are talking about. Now, when we say by performance, to what are we trying to say? Okay, so we are trying to say that one, put it in mind that by performance, you can discharge a contract by performance. One, each party does, let's say, what they promised, right? Whatever you promised, when you are done and both parties are dealt with it, yes, you can discharge the contract. Then you can also say, because it is based on what performance, if only one party performs, that party is free from the contract and can sue the other party for not doing their part. Okay, so let's say we entered into agreement that you are supposed to do this thing for me and I'll do this thing for you. Once I've done my part and you are refusing to also oblige to whatever that was stated in the contract, it means I can sue you. I hope that is clear. Yeah, so that is what we are talking about here. So for example, let's say if I agree to paint your house and let's say you propose to me that you want me to paint your house for 5,000 Ghana cedis and I agreed. This one, there's agreement, right? So once I finish painting the house, it means I have done my part. So your part is to also what pay me what in full. That is what the 5,000 Ghana cedis. Okay, so when we say by performance, I'm doing it or I've done it, so you also have to do your part. Okay, so in a situation whereby I finish painting the house and you refuse to pay me, okay, that is when I can sue you for breach of what contract. Okay, yes, and let's also look at another part of which we call substantial what performance. So with the same scenario that I'm talking about, substantial performance is when the fundamental requirements of the contract have been completed. So the same example that I used, you told me to paint your house for 5,000 Ghana cedis, right? Yes, I've done that. Now, that is the core duty, right? Or that is the fundamental duty or the requirement of the contract for me to paint the house. A situation whereby I finish painting and I do not clean the paint on the floor does not mean I'm not done with the work, so you are not going to pay me in full. When you take me to court or when I take you to court, yes, you are going to pay me in full because the fundamental requirement of the contract have been what completed. Cleaning of the floor, or trying to remove the excess paint on the floor and the rest, that one is just other work. Do you get it? Yes, I can choose to do it, I can choose not to do it, because upon agreement I was supposed to paint the house, and now I'm done painting, so that is my work. Okay, so another example is, let's say for example, where the construction of a road has been completed, leaving out the planting of grass to check erosion at one end. Okay, so let's say you've given me a contract that I should what construct a road. Now once I'm done with the construction of the road, that is all, you have to pay me. Okay, if I don't plant any grass alongside the road or whatever, yes, I'm not entitled for any liability or any minor work. Okay, so all that you are going to do is to pay me in full. Yes, that is substantial performance. So when you are able to execute the core duty, that is substantial. So let's say by agreement, let's look at the second part. The second part is by agreement. So both parties can agree to end the contract before it's completed. Don't forget the subject topic that we are talking about. Ways we can discharge what a contract. How can a contract be discharged? And second, we are saying it is what by agreement. So both parties can agree to end the contract before it's completed, right? So for a typical example is, let's say a musician and event planner or event organizer. If maybe we agree to organize a concert, okay, then before the date or before the concert, there is maybe misunderstanding between us. So the both of us agree to what discharge the contract. Yes, it holds to stand, right? So by mutual decision, we can go into the agreement. Then if I understand, if I say maybe we should just discharge the contract and you understand, that is by agreement. So we can just discharge it. Okay. Then let's move on to the third one, that is by frustration. Okay, by frustration. So when we say a contract can be discharged by frustration, what are we trying to say? Frustration here is we are talking about unexpected what event. Okay, so a contract can end if something unexpected happens that makes it impossible to carry out what the agreement. So something unexpected what happens. Now let's say I have booked a hall for a wedding ceremony. Okay, then maybe a week to the wedding, that hall or that place that I'm going to use for the wedding ceremony has been burnt down, right? So since the place is no more, then it means no one is at fault. You the one accepting my offer, or you the one accepting my proposal to use the hall, you are not at fault. Okay, and let's say the one also issuing it is not also at fault. So the two parties, no one is at fault. So in that situation, we can discharge the contract. Okay, yes, that is what we mean by a contract by frustration. So have it in mind that a contract by frustration is the same as what unexpected what event. Okay, then let's look at another one. So here we are saying Ghanaian position on frustration. When a contract is considered frustrated, the contracting parties are considered discharged from further obligation. Of course, money is recoverable and money due to be paid should not be paid. Okay, when one party has spent any money in preparing things in the contract, and so all that they are trying to say is that yes, I booked the hall, right? And now the hall is what no more. You are not at fault, I'm not at fault, but what do we do? Money is paid, right? Oh, sorry, money paid is what recoverable, and money due to be paid should not what be paid. So what I'm saying is that now the place is no more. So what do? I'm not going to pay you, right? Or if I had already paid you for a certain hall or a place to use, but the place is no more, it means what you are supposed to do is what you refund the money to me. Okay, that is why we are saying money paid is recoverable, because if I pay the money, you need to refund me. Okay, and money due to be paid should not be paid. Okay, yes, that is what we are talking about. And the next one is by breach of what contract. So by It is the refusal or failure by a party to contract and fulfill an obligation imposed on him under the contract. This may result from repudiation, right? Repudiation is the same as reject of liability before completion or conduct preventing proper performance. Okay, so by breach here we are saying if one party fails to do what they promised, especially something very important, right? So something very important here is what the condition, right? Yes. So the contract is broken or breached. The innocent party can then treat the contract as over, or that person cannot sue the one who breached the contract. I hope you get it. So a typical example is, listen, I bought something or I ordered something, and they were supposed to what? Upon contract, I'm supposed to receive the items maybe at 3 p.m. And so if I don't receive the items at 3 p.m., but rather 6 p.m. or 7 p.m., then it means there is what? Breach of what? Contract, because at that particular 3 p.m., maybe I needed the item for something serious, but then because you couldn't provide me those items or the good or the product at that particular point in time, it means there is breach of what? Contract. I hope you get that. Yes. So let's read this question. It says Kwame hired a room to view the Hobochocho festival, which is held every year. He hired the room for 12 days only. Unbeknown to both Kwame and the landlord, the festival had already been cancelled for security reasons. Kwame is refusing to pay the landlord for the hire of the room. Which of the following statement is correct? Yes. A. The contract is frustrated, right? Yes, because even if Kwame paid the money for the room for the purpose of the Hobochocho, right? Now the purpose here is what? Hobochocho. And Kwame paid for the room for the intended purpose of what? The Hobochocho festival. And now because the Hobochocho festival has been what? Cancelled, it means even if Kwame paid the money initially, the landlord is supposed to refund what? The money, because I made it clear to you that I'll be using the room for 12 days for Hobochocho, or whether if I'm going to sell there or I'm going to do something there 12 days. But since the festival is not coming on, I don't need the room anymore. So if I have paid you, just refund me. If I haven't paid, it means I'm not supposed to what? Pay. I hope you get it. So the contract is what? Frustrated. I hope that is clear. So let's move on to the remedies in contract. Here we are saying if a contract has been breached, or if a breach is threatened or imminent, there must be a remedy, right? The injured may have several courses of action open to him. The underlisted remedies are available to him. So we are saying one is what? Damages. 2, quantum meruit. 3, money had and received, specific performance, reinstatement, injunction, rescission, and rectification, right? So let's look at them one after the other. Okay, so for damages, we are saying damages is the court's estimated compensation in money for the detriment or injury sustained by a claimant. It is a means of monetary award to place a party of a contract in the position he would have occupied if he had not suffered the wrong complaint, right? So damage is recoverable if it results from the natural consequences of the breach or from special circumstances of which the parties had actual knowledge and which caused the breach to result in exceptional loss. So we are saying this money paid to person who suffered a loss from the breach of contract. The main reason why we pay this money to the person is that we want to put the person in a situation or position where if everything was to come up successfully, yes, that person would be in that position, right? Because we don't care about causing a damage or harm to that particular person. I hope you get it. Yeah. So a typical example is if a seller fails to deliver goods, you see the buyer sues and gets the price difference between the market price and the contract price. I hope you get that. Or let's say a situation by the last example that I used was event organizers and let's say a musician. So now we have agreed that we are going to hold a concert. Now, if the singer cancels the paid performance last minute, so you know some of the musicians or artists, you pay them half of the percentage before coming, right? Then after performance, you pay the rest. Then so for let's say I have paid you to come and come and perform at a certain event. Then you tell me last minute that you wouldn't be able to come. Then the event organizer can claim damages for the loss of what ticket sales. I hope you get it. Yes, so they can claim damages. All right. Then it says, note, in calculating damage tax liability of the one who suffers the breach have to be taken into account by deduction because he may receive more than restitution, right? In contract of sale of goods, the measure of damages is the difference between price at the date of the breach and the contract price. Yes, that is what I said. So it is the price difference between the market price and the contract price. You have to compensate that person between those two prices. I hope you get it. So the market, if the market price is um, let's say 5,000 Ghana cedis of a laptop, then the contract price is also around 5,500 because since it is contract, it comes with a lot of or certain activities. That is why there is increment, right? So you have to pay me the difference, right? You have to pay me the difference. So don't forget this. Then let's look at the quantum meruit. Okay. So the quantum meruit here means as much as is deserved, right? As much as is deserved. So this means payment for already work done, right? Especially when there is no agreed price for the contract. No, when there is no agreed price or the contract becomes void and incomplete. I know you know void and incomplete, right? Yeah. So let's say for the quantum merit, it means as much as he has earned. Yes. An injured party in contract may be entitled to claim for work done and services performed on breach of what contract. Yes. A typical example is, let's say there is no when we were having a contract. Okay, when we were having a contract, although we didn't have any specific amount to be paid at the end of the contract, right? But or we didn't add a clause whereby if I'm not able to complete the work, you are supposed to pay me this. Okay, yes, but a situation whereby you have given me a house to paint, right? Let's say 4 story building. Okay, 4. Then I am done with 2. Then you come and tell me I'm not doing it well and this and that, so you want to call the contract off. Now because I have done some certain parts of the contract, yes, you need to pay me some percentage. I hope you get it. That is the quantum merit. That is why we are saying as much as is deserved or as much as he has earned. I hope you get it. Okay. So that is what we mean here. Or you can say maybe a builder starts work, but the owner cancel before the completion. The builder can claim reasonable percentage for the work done because I didn't ask you to cancel it. I was on the verge of completing it. So I finished 50% of the work. It means pay me 50% of the work. I hope you get that. Yes, and that is quantum merit. Then money had and money what received. Okay. If someone pays money under a contract that fails completely, they can ask the court to order a refund. I hope you get that. For example, you pay for an event, but it gets cancelled before it starts, right? You can recover the money. So you want to go and enjoy a show by your favorite artist. So you bought the tickets yesterday, just to realize this morning the show has been what, cancelled. Yes, they will just refund the money what to you. I hope you get that. Yes, or you can call for what, refund. That is it, and that is what we mean by money had and received. Right. So when money had has been deposited or paid on a contract, and before any benefit has been derived by the payer, or any part of the contract has been performed by the other party, the consideration will wholly fail. Right. An action for money had and received may be maintained to recover the money so deposited. The term is a term in law. Okay, so just have it in mind. Money had and received. Okay. So let's move on to the next one. Let's see if we have another one. That is specific what, performance. So don't forget, we are talking about what, the remedies. Okay, in case when someone breach a contract, some of the what, remedies. Okay, yes, some of the things that we make sure they are in order, right, in order for let's say one party breaching the contract to enforce any other action. Okay, so the fourth one is specific performance. It is an equitable remedy and discretionary. It is an order of the court compelling a party to a contract to perform exactly what he had promised to do. So it thrives on the basis that in some circumstances the payment of damages would not provide an adequate remedy. Note it very well. The payment of damages would not provide an adequate remedy. For example, a contractor who fails to build after payment of advance may be compelled to perform instead of only claim of what, damages. Okay, very simple. So a court can order, or a court can force someone to do exactly what they agreed in the contract. It is used when money alone is not what, enough. Maybe you are supposed to do something. You have what, defamed someone. Most of the time, if you defame someone, yes, it's not only that the person will ask for what, compensation in a form of money. The person can ask you to just go to the public, wherever that you stood to defame the person. The person can just tell you to go there, then to rectify yourself. Okay, yes, to rectify it yourself. And so that is the specific performance that we are talking about here. Okay, so let's move on and see whether we have another one. So another example is, let's say, okay, as a contract for the sale of goodwill of business without premises, contract in which only one side enforces. Okay, so you can talk about, let's say, the same painting that I was talking about. Okay, yes, if let's say you come to me and you ask me to what, paint your building, right? Then I accept what the terms, you pay me in advance. Then maybe later I'll just stop. Okay, yes, the work will be stagnant. I'll just stop. So in this situation, the owner, okay, or you can the contract one, the opposite party, right, can send you to court. Then he will just order the court to ask you to do exactly what you were supposed to do, not to take the money back, right? But the court will just force you to do what exactly you were supposed to do in the contract. Okay, then let's look at the fifth one, that is reinstatement. So this is mostly used in, let's say, the employment contract and the rest. So the court may order an employer to give back a job to someone. Maybe that person was fired wrongly. Okay, this thing I remember my JHS. Yes, one of my teachers caned the proprietor's son. So when the proprietress came, I think the teacher was called to the office and he was sacked. And the next day, the teacher came back to the school, just for us to realize that the case was sent to the court that very day, and the court reinstated that yes, the teacher must still come back for the job. I hope you get it. Yes, as simple as that. So if, let's say, in employment arena or zone, if your boss or someone fires you wrongly, you don't know what you've done to him, you don't know anything about the reason why he or she is trying to fire you. Yes, you can send it to courts, and per investigation or everything, yes, the court can let the owner of the business reinstate you back. I hope you get it. Yes, because he has no reason to sack you or fire you. That is reinstatement we are talking about. I hope that is clear. So let's move on to another one. Don't forget, we are still looking at what the equitable remedies. Okay, yes, for a breach of contract. So when you breach a contract, what happens? The kind of things that happens, what the court does. That is what we are looking at. So the sixth one is injunction, right? Injunction. So injunction is just a court order that will just tell someone to stop doing something. Okay, if especially if what you are doing is prohibited, right? Let me say that prohibited, or to undo something already what's done, right? So let's say the court can order an injunction on, let's say, on an election. Okay, yes, maybe if there is an election and there is this kind of manipulation and all that, yes, the court can just put some injunction on it until further notice. And sometimes too, if you are building a house or yes, a factory at waterlogged area, that will cause, what do we call it, that will cause flood and disaster, or that, yes, the Metropolitan Assembly, they can acquire an order of injunction from the court so that they let you stop working. So you see, maybe they've written on the wall, yes, work must stop, prohibited something something. So that is the injunction we are talking about here. Okay, yes. So let's say if you were a builder, right? If you were a contractor, right? Yes. If you were a builder, then you are building on someone's land. Okay, you are building on someone's land by mistake, you don't know, or even if you know and you are building on someone's land, the court may order the particular person to remove that particular building. Okay, so it means remove means you have to what, dismantle it. Wherever you have gotten to, whether you are building a factory or you have already built it, you still have to collapse that particular building. Okay, so let's move on to the next one. That is what, 7. Another remedy for breach of contract is rescission, right? Rescission. So rescission is sometimes known as repudiation. It is a remedy granted to one contracting party to avoid or set aside a contract. So a party intending to rescind must notify the other party, right? So a rescission ab initio results in the contract being treated as though it had never existed. Okay, so for example, let's say you buy a car thinking that the car is new, but you later, or on that particular day after getting the car, you just realize the car turns out to be used, right? Yes, you can just rescind, okay, the contract and return the car. You can pretend as if the contract never happened. Okay, yes. So that is the rescission we are talking about. You can just reject the contract or you repudiate. Okay, you can just pretend as if nothing happened. Okay, so that is the rescission we are talking about. So it says grounds that may justify rescission include: 1, fraud. Yes, you told me it's new, but then I later realized it's not new, and you told me this one is what, let's say iPhone 11 Pro Max, just to go home and realize it is a soap. So there is a fraud there. And misrepresentation to, let's say, a seller lies about a particular property size, and so maybe if acquiring that particular product you realize, oh, there is whatever he or she said is not true, it means there is what, misrepresentation. And the third one can be what, a mistake, maybe the seller did not even know about it. Okay, yes. So let's talk about the last one, that is rectification, right? I think that is the last one. So when we say rectification, this is used when there is a mistake in the written contract and one party asks the court to correct it to match the real agreement. So this one, You are there to rectify it. I hope you get it. You are just there to correct it. So maybe in the contract, you wanted 30 books and the person wrote what? 300 books. I hope you get it. So in this situation, yes, you can go to the court and you let the court correct that particular thing in the contract. The more reason why it will be the court to correct it is that now per the agreement, it must be enforceable. It must be legally what? Binded. So the court has to what? Stamp it before it becomes an official, or it must be of a legal what? Necessity, right? Before it can be a contract. So once there is a mistake, you take it back to the court to rectify it, and that is what we term as what? Rectification. Okay. So thank you very much for joining us in today's lesson.